Imagine you get that call the day before closing and you're working with a buyer and they say, "Hey, is it too late for me to get out of the contract? What if I don't want to close tomorrow?" And I have a suspicion I know what your reaction might be because I've been there and done that. But this is something that we might run into from time to time. And in fact, just today, I was talking to one of our Pro Access members about this exact situation, only she's on the seller side of the deal. And the seller is contacting her and saying, "Look, I don't want to close. I'm not wanting to go ahead and sell my house. I want to get out." And here we are. We're past inspections. We're past time. I mean, we're at the eve of closing here. And so our Pro Access, of course, is our community where we help people navigate these kinds of problems every single day. And if you're interested in having a resource like that in your business, then check the link in the description where you can see a little bit more about what our Pro Access is and how we can help you navigate these tricky things. But let's talk about a breach of contract and what the remedies and rights are of buyers and sellers. Now, of course, I am a lawyer, but I'm not your lawyer, so nothing in this video is legal advice. Instead, this is here to help you recognize what the issues are, be able to spot when things become a potential problem so that we can say, pause, this might be where we want to spend a little bit of time and a few bucks to talk to a lawyer before you go any further, because this might be a breach of contract and we don't want to go too far down the road because there's real consequences for it. And so when we go beyond our real estate license to advise people in instances of breach of contract, just be careful because that could be the unauthorized practice of law. And if you make the wrong step, it can cause some real consequences for you and for your clients. And so this is more about issue spotting and not actually advising them of breaches of contract, but recognize when it's an issue so we can hit the brakes. So let's start by looking at the contract to see what exactly does the contract say, because there's a difference a little bit between what the contract says and what is practical. And I'm always one that I want to help you navigate, not just to understand what the legal issues are and what the contract says, but also let's talk about the practical side of things, because what the contract allows and what practically might happen can be two separate things. So getting into the contract, we recognize in paragraph 16, it tells us what a breach of contract is and what happens. And that breach is basically saying if either party fails to comply with any material agreement in the contract within the time limits, because of course, time is of the essence, which means deadlines are hard deadlines. And so we need to recognize that we got to do the things by the deadline and we've got time limits. And if we don't do them, then here we fall into the breach of contract. And so let's start with the seller because they come first. So what can happen? If the buyer does their job and the seller fails to convey title or perform their obligations, then the seller could be in breach of contract. And the buyer basically has two options here. The first one is to terminate the contract by giving written notice of termination. So they would send a notice of cancellation. They would return the abstract to the seller. I mean, although most of the time they won't have it, title will, but the abstract goes back to the seller and the buyer gets a refund of their earnest money. Now, in reality, like this is what is often going to actually happen in the event of a breach of contract by the seller, because we'll look at number 2 here in a second, but for the most part, what we end up seeing is what are the actual practical implications for a buyer to pursue something else? Okay. So one option for the buyer is to say, you know what, then forget it. I'm out of here. Give me my earnest money back. Here's a notice of cancellation. But sometimes a buyer doesn't want to do that. Sometimes a buyer wants more because in reality, the buyer could have some real harm. They've had the time, maybe they're selling their house and now they have a problem because they can't buy this one because the seller's backing out, because they're, trying to close on one and buy this one on the same day. They could be out the costs of inspections and things like that. And so we have to look at what that actually looks like under the contract. So we said that was number 1, what the buyer can do is just cancel the contract, get the earnest money back. 2 here says they can pursue any other remedy at law or in equity, including specific performance. Now, let's touch on specific performance here for a second, because what is that? Specific performance means, hey, I'm entitled to buy this thing, this house. And so I'm going to go to the court and say, Judge, I want you to force them to sell me the house, force them to follow what they said they were going to do under the contract. Now, the reality with specific performance, while it kind of makes sense in this context, because specific performance is what we call an extraordinary remedy. That means it's a remedy of last resort, which means if there's any other remedy we could give the buyer that will make them whole, then we are going to do that, as opposed to force the seller to sell the house. Doesn't mean it's not, it's impossible to get specific performance, but you got to recognize it's really unlikely. It is a last resort type of remedy, and most courts are going to be very reluctant to actually force the seller to sell the house, especially if they can find something else that will make the buyer relatively whole. Okay. So theoretically, we could ask for specific performance, but the other piece of this is pursue any other remedy at law or in equity. And this includes things like actual damages. Okay. And so perhaps the buyer does have real damages. That could be, the cost of inspections, the cost of title fees, and any number of other things that they might have incurred in trying to buy this house that now they're out that money. So theoretically, a buyer could then go to court and say, hey, judge, I want my actual damages. I want to be refunded for the costs of my inspections and so forth. And I think that's a potentially legitimate remedy that a buyer would be entitled to. And I could see a court actually granting that. Specific performance, pretty rare. Damages in those cases, sure. But let's talk about the practical side of a buyer actually pursuing a lawsuit against a seller. Now, most of the time, when you want to sue somebody, you probably want to hire a lawyer. That's just kind of the reality of it, that most people don't want to go do it themselves. They could. Small claims court is for that. That's absolutely an option in something like this. But if you wanted to hire a lawyer, the practical reason why this is such an issue is that by default, contract breach claims do not entitle the winning party to attorney's fees unless the contract allows for attorney's fees. Instead, the default rule in Oklahoma and most states is that the party pays their own attorney's fees unless you either have a statute or the contract allows for attorney's fees. And we don't have a statutory attorney's fees provision, and we don't have anything in the contract that allows for attorney's fees. That means for a buyer to sue a seller, they've got to pay their own lawyer. And so maybe they are out several hundred, couple $1,000s, but what's the cost to hire an attorney to go after that going to be? Oftentimes, it's just not worth it financially. I mean, we can talk about the realistic, practical side there, that it's very difficult to actually pursue that case. And how long is that going to take? And is it really worth it? And unfortunately, that means the buyer is harmed. They're often without a great remedy because we can't get attorney's fees. And so we typically end up seeing that defaulting back to paragraph or that little sentence 1 that says, terminate the contract, get my earnest money back, cut my losses, and move on. Now, that doesn't feel fair, but the reality is that in contracts, there's no such thing as fairness. It's just what's on the paper. And in this case, there's a lot of disincentive for a buyer to sue a seller unless they just have the funds to do it, or they're going to go to small claims court where it's cheaper and quicker to handle on their own. Certainly an option. But in reality, just need to recognize that suing the seller oftentimes isn't going to be worth it because of the cost and inability to recover attorney's fees. Unfortunately, that sometimes leave a buyer without any really good remedy for themselves. And so let's look at the buyer side, though, and see if it kind of works similarly, right? Because when we have a breach by the buyer, we have this same sort of thing where when we really get down here into the meat of, say, that last minute, just to simplify things, a buyer at the last minute says, I'm not going to show up. And so if the sellers perform their obligations and the buyer fails to provide funding or perform their obligations, then what can the seller do? At their option, they can do a few things. One is cancel and terminate the contract. And then it says, and retain all sums paid by the buyer, but not to exceed 5% of the purchase price as liquidated damages. Okay, let's talk about that because this is kind of an interesting provision. And so what does that mean? Well, that's generally the earnest money, right? The seller's going to say, okay, fine, buyer, you breached the contract. Well, then I want your earnest money. I want to, as the contract said there, retain all sums that you've already paid, but that can't exceed 5% of the purchase price. And we call that liquidated damages. And what that means is liquidated damages is a term that says, look, it's really difficult to calculate actual damages. I mean, what are the actual damages in a breach of contract when a buyer walks away? It's difficult to calculate. It's kind of a messy calculation to figure out what that is. And so liquidated damages said, we're going to agree up front that if you breach, this is what the damages are. And so that is the prepaid amount, the earnest money paid by the buyer, but there's a cap on it at 5%. And that's because we have a state statute that says a liquidated damages provision in a real estate contract can't exceed 5%. So that's what that is, and that's what we often see. right? So often for the seller, it's going to be, all right, buyer, you breached the contract. Well, then I want to keep your earnest money. And if we had to go to court to try to enforce that, that's the provision that the seller would be relying on. It's this one right here to say, here's where the contract says I can do that to keep it as actual damages. It's not the only option that the seller has, though, because we see this same provision that we saw on the buyer side is pursue any other remedy available at law or in equity, including specific performance. Now, I told you before that specific performance would be rare for a buyer to get against a seller. For a seller to get it against the buyer would be even more rare. That would be such a bizarre thing to see because, again, the idea of specific performance is that there's no other remedy that will make that party whole, that there's no way to fix the issue for them in something other than forcing, in this case, the buyer to go ahead and purchase. Well, look, we can find another buyer and we can give the seller actual damages. We can to figure out what it is. And that would be sufficient to actually force a buyer to purchase. I just can't even fathom in what world and what scenario that becomes a likely outcome. Theoretically possible, sure. Likely, not very, because specific performance goes back to the idea that the thing I want is unique. There is no alternative. It's like that rare Picasso painting. It is the only one in existence. I can't go get a different one. There is no alternative. I want that one. Specific performance makes sense. Again, a buyer with real estate, that's the only house in that specific location that exists. There isn't another one exactly like it. Specific performance starts to make sense a little bit. But for a buyer, I mean, we can eventually find another buyer. So that's a bizarre thing to almost see in the contract and very unlikely that we would see that. So I wouldn't want a seller to get their hopes up that they would actually be able to achieve specific performance against a buyer. Maybe, very unlikely. But it also had that same language of pursue any other remedy at law or in equity, right? So what does that mean? Again, it could be things like actual damages. And so what does that look like for a seller to say, well, you know what? I'm going to pass on the earnest money. Because the way it would work in practice is they'd go file a lawsuit and say, Judge, I want actual damages. And if that's not, appropriate or we can't figure out or it's not enough, then maybe we'll get earnest money instead. It's not both. It's earnest money or actual damages in that case. Now, this is a difficult one for us to figure out what actual damages even look like. And the law kind of establishes an interesting way of looking at it. And so we can look at this damages statute in state law that calls about the detriment caused by a breach of agreement to purchase. And so they say here that the detriment, so the harm caused by breaching an agreement to purchase an estate and real property. So a purchase contract, you breach it. And so they're saying, what is the calculation of damages if that happens? It's deemed to be the excess, if any, of the amount that would have been due to the seller under the contract over the value of the property to him. Okay. This is old language. This is kind of difficult to parse through, but luckily there's case law on it. And so what we're looking at here is, okay, the excess between whatever the purchase price was, what did we agree to, and the value of the property to him. And this is generally established at the time the breach occurred. So, what is that calculation? I don't know. I mean, that could be very difficult to pinpoint, right? What is the value if we enter into a contract on March 1st and April 1st, the buyer breaches the contract? What's the value on April 1st when that breach occurred? I don't know, it's difficult to establish. Now, one way we might do that is we relist the property. We get it back under contract. And let's say we were originally under contract for $300, and then this new contract that comes in, the best that we could do is under contract for $290. Maybe we try to make the case that $10,000 difference is the actual damages. That might be one argument that we have. Maybe we already had an appraisal and then we can figure out when the breach occurred. I mean, there's a lot of ways you might do it, but again, what you see is it's difficult. And the little bit of case law that we have on it recognizes that establishing actual damages in the case of a breach of contract case for a seller is difficult. It's challenging, which is why we have that provision that says, okay, first we look at earnest money. That is the most likely result. And again, just like we saw with the buyer, when we look at this, there is no attorney's fees provision. So a seller can't hire a lawyer, go after the buyer, and also force the buyer to pay their attorney's fees. The seller's going to have to pay them themselves. So where does that leave us? I mean, where it leaves us is the reality that it's very unlikely that we're going to get actual damages because it's difficult to calculate for both the buyer and the seller. It disincentivizes us in the contract to actually pursue litigation. We don't want people to sue each other, and the contract doesn't really promote it because it doesn't allow for attorney's fees. So a lot of attorneys, if you're not going to be able to pay them out of pocket, they're not going to take the case because we can't recover those fees. And so where are we left? Well, oftentimes not anywhere that's very helpful to either one of the parties. Certainly for the seller, getting earnest money is relatively straightforward. That's pretty clear under the contract as liquidated damages, assuming there was a breach. And for the buyer, I mean, oftentimes there's just not a lot of good options. And so they end up being left to hopefully try to negotiate something that makes everybody whole and settle it, or at least relatively whole, that we try to figure something out. But again, let's go back to what is the purpose of why we're talking about this, right? So you can recognize how the breach of contract might work in reality a little bit, the practical side of it. But let's recognize this. When these instances occur where there might be a breach of contract, what's your role as the real estate professional in the transaction, or one of the two real estate professionals in most cases? Well, it's to recognize the issues. I want you to see the future a little bit. I want you to issue spot. I want you to see where the problems are so that we can get the party to pause and say, this might be where you want to consult an attorney before you go and make some move. Because depending on what we do, that can have consequences for whether we have other remedies later or not. What I mean by that is if we don't treat the breach of contract appropriately when it occurs, that could potentially be a waiver of the rights that party has if they continue to negotiate, pretend like it didn't happen, or try to say, well, I'll just come back to that later if something else goes wrong. It doesn't really work that way. And so we just have to recognize that sometimes it makes sense to pause, tell the party, this could be a breach of contract. This could cause consequences for the parties. We might want to stop and talk to a lawyer about it because this could have repercussions for what happens next. Often in these moments, not in the 99% of time when things are going smooth, but these 1% of times that get really complicated and chaotic, it can feel like you're going at it alone and you're not sure if you're handling it the right way. That's what we're here for. That's what our Pro Access is. So if you're interested in learning more about that, check the link in the description to see how our Pro Access can give you that little backup when things get complicated.